Morning, everybody. Welcome to session 5 of our construction law training. Today we're going to cover our overview of dispute resolution. You all know by now who I am. I'm Hannah McNabb, partner here at Archer, the H in Archer. I mostly do dispute stuff, and a big part of what I do is adjudication. So I'm really happy to be talking about that today. I am joined by our brilliant senior associate, Liam. And I'm not sure if I'm allowed to say this, but I'm going to say it anyway. Liam has just recently been promoted to legal director, so we'll be announcing that in a couple of weeks. So we're really proud of him here, and I'm really delighted to have him here today. I'm just going to let him say a couple of words about himself now.
Morning, everyone. As Hannah said, I'm currently a senior associate at Archer, predominantly work on the dispute side, and a big part of that, again, similar to Hannah, is adjudication. I changed careers about 5-6 years ago, and prior to that, I worked in commercial roles in the construction industry. So I'm a rare lawyer who, one, can work a spreadsheet, and two, knows what a CFA pile is.
Very handy to have in the office. As you all know by now, these are the partners. We set up Archer 5 years ago, doing everything construction law related. And if you've been with us for all the previous sessions, you'll know by now there are 26 of us in total, all specialising just in construction law. We're East Anglia based, so we've got offices in Colchester and Cambridge, but our client base is spread across the country, and we've got a bit of international work as well. So this is what we're going to cover today. We're first going to look at the different types of dispute resolution before we move on to my very favourite topic, adjudication. On adjudication, we're going to cover the process, key issues with some relevant case law along the way too.
Okay, so we're going to start by looking at different dispute resolution options. 3 forms of what we call formal dispute resolution, and that's putting adjudication to one side. All of these have different sort of timescales and processes. Some are public, for example, court proceedings, and some are not, i.e. arbitration. The first one's expert determination. Expert determination is a process where a discrete issue or dispute is referred to a named expert who gives a final and binding decision. That's in contrast, for example, with adjudication, where the decision is temporarily binding. In a construction context, expert determination is useful where there are technical issues, for example, the functionality or testing and commissioning of plant or certain equipment, and that's probably why it's used, as the slide says, in IChemE and MF1 standard forms, which might be used in sort of chemical processing or sort of manufacturing type context. The expert determination process is that the parties will exchange written submissions or evidence, not dissimilar to adjudication. There might also be a site meeting or a site visit, especially if the adjudicator needs to see a certain piece of kit on site. And then the expert will give their final and binding determination.
So the next type of dispute resolution I just want to talk about is arbitration. The first point is that arbitration is not adjudication. Now, you may laugh at this and think it's obvious, but many people think they're the same thing, and they are not. They are completely different mechanisms. So arbitration is basically an alternative to court proceedings. So arbitrations are private, unlike court, whereby it's in the public domain. Now, arbitration is conducted by an independent and neutral tribunal, typically comprised of 1 or 3 arbitrators, and they act in a quasi-legal capacity, so like a judge. Now, the process is similar to court proceedings, and the arbitrators hear evidence and arguments from both parties, and then they issue a decision known as an award at the end. So that award is final and binding, and it's enforceable, so it's very similar to a court judgment, and there's really limited rights of challenge or appeal unless it's under specific circumstances. So again, similar to court proceedings. As I've said on the slide, arbitrations are governed by the Arbitration Act or by pre-agreed rules. It depends what the contract says, and there's different arbitration rules that are around. So the key point of arbitration is that the parties must have an agreement to arbitrate in place. And if they don't, the default is that court proceedings is the only option to take a dispute forward. So JCT, for example, has the option of arbitration, but only if you specify this in the particulars. If you don't specify it in the particulars, you can't then issue an arbitration if you have a dispute. Now, the main reason why arbitration is chosen over court proceedings is privacy. So arbitrations are private, court proceedings are not. So if you don't want it to be in the public domain that you're having a bum fight, arbitration is the way to do it. Now, arguably, the cost and the time incurred in an arbitration is similar to what you'd incur in court proceedings. However, in arbitrations, you'll also have the cost of the arbitrators, and that's going to be significantly more than the court fees that you're going to pay in litigation. The pro to this, though, is that the parties can agree who the arbitrators are. So in court, you're just given a judge. You have no choice which judge you get. In arbitration, the parties can work together and get the right tribunal for them. Now, one further point to consider with arbitration is what if there is more than one party to a dispute? Now, this is really common in construction claims, which Liam's going to come on to shortly. But you may have a claim that involves two or more contracts, so a claim by the employer against the contractor under a main contract, but the contractor wants to pass that claim down to the subcontractor under the subcontract. So you've got two separate contracts there where there is a dispute. But arbitrators have no unilateral power to order consolidation of those arbitrations. So you need the consent of all parties for that to happen, which quite often isn't given. So you end up with multiple arbitrations leading to multiplication of costs and potentially incompatible decisions. So you therefore need to think really carefully at the time the contract is entered into about whether you want to arbitrate or go to court if a dispute arises.
Okay, so the slide shows the structure of the English civil court system, which is generally where most construction cases are dealt with. Occasionally there'll be a criminal aspect to a case, so for example health and safety breaches, but for the most part almost everything that we do is dealt with by the civil court system. High value and technical construction disputes are usually dealt with in the Technology and Construction Court, which is a division of the High Court. We're really lucky in this jurisdiction that we've got a specialist court that's dedicated to construction and technology disputes. It's based in London at the Rolls Building, which is near Chancery Lane. There are various district registries, so the closest to where we're sitting, for example, might be Birmingham or Bristol. We've mentioned the county court on the slide. Generally, that's not the place that you want to be with a construction dispute. It's without getting too political, it's underfunded, so it's a fairly long and arduous process. You might be dealing with a judge who's not necessarily a specialist in construction, which is not a problem that you have in the TCC. My general view is that if you've got a lowish value claim that would end up being in the county court, then you're most likely better looking at adjudication. Okay, so to talk about the TCC a little bit more, and just as an aside, that's Rob Rinder on the screen, and Hannah was fortunate enough to meet him at last year's SCL lunch. So as I mentioned, the TCC is part of the High Court, specifically the business and property courts in England. Usually it takes sort of 2 to 3 years to get to trial in a TCC claim, although I think I read some stats a year or two ago to say that only 80% of cases don't get to trial. They end up settling before, so it's quite rare to get there. In court proceedings, the costs, i.e. the costs of us, for example, experts, court fees, are generally recoverable, and the overriding principle is that costs follow the event. So effectively the loser is ordered to pay the winning party's costs. Most cases in the TCC, until you get above £10 million, have a sort of cost budgeting process where budgets are exchanged between the parties. You each comment on them, and the court ends up making what's known as a cost management order, which sort of underpins costs during the process of the case. Okay, so this slide shows the sort of general structure of parties to court claims. Usually on the type of claims that we work on, there'll be one claimant and one or maybe two defendants. You can also get what's shown on the screen as a Part 20 defendant, which is where a defendant has added in an extra party. So let's say, for example, you've got a situation where the claimant is the employer and the defendant is the main contractor. If, let's say, for example, we're talking about a cladding claim and there's a cladding subbie and an architect who's designed the cladding, the main contractor might want to bring those two parties in as Part 20 defendants if they've contributed to the loss. As Hannah mentioned earlier, for those reasons, you really want to ensure that the dispute resolution provisions in your subcontract and consultant terms line up with what's under the main contract, because if there is a situation where you want to bring the supply chain into an upstream dispute, you don't want to be stuck in a situation where you can arbitrate upstream but not downstream, because you probably won't be able to bring those parties in.
So moving on to the more informal forms of dispute resolution, the first I've put on the slide is conciliation. Now, this is relatively rare in relation to construction projects in England, but there's no reason why the process couldn't be used. I was speaking to someone in the office there, but I understand it is more common in Ireland. So it involves appointing an impartial third party, so a conciliator, to assist the parties in resolving the dispute rather than making any sort of decision. But the conciliator will take a proactive role and independently assess the merits of the case, and he will make suggestions about settlement and sort of comment on what he thinks is a fair resolution. Now, this is slightly different to mediation, which is the next one on the slide. So that's a facilitative process where an impartial mediator helps the parties that are in dispute to communicate and to understand each other's perspectives and explore options for resolution. Now, the mediator, again, won't come to a decision or judgment, but also the mediator won't express a view as to the merits of either party's case. He's just there to try and resolve the dispute. So mediation is more common than conciliation, but mediation tends to happen as part of one of the more formal dispute resolution procedures. So parties in court proceedings are now obliged to mediate in order to try and settle the dispute. Now, this normally takes place once the parties are aware of the claim and the defence, but it tends to happen before witness statements and expert reports are exchanged. But realistically, this can happen at any point, right up the way to the trial. Another informal option is early neutral evaluation. So here, an evaluator assesses and evaluates the facts, evidence, and legal merits of a case or specific issues in the case. Now, the evaluator will provide an unbiased opinion on the strengths and weaknesses of the parties' positions, but the evaluator's opinion isn't binding, so the parties don't need to accept it. Now, the last thing I've put on the slide is talking. Some people say that the only people that benefit from disputes are lawyers. Naturally, I don't agree with this statement, but we will always encourage clients to keep talking to the other party where possible to avoid what can start as a minor issue escalating into a large dispute that costs both parties time and money. Now, if you are going to try and settle a dispute amicably, there's just a few points that I want you to be aware of first. So I'm going to quickly cover these off. And they're basically the differences between open discussions without prejudice and without prejudice save us costs. So the first point to note is that all correspondence, whether it is written, phone calls, in a meeting, minutes after a meeting, anything like that, that is all open. So what I mean by this is that either party can rely on that correspondence at a later date, for example, as part of their claim in court proceedings or in an adjudication. So it's therefore really important to think carefully about what correspondence you want to keep open. Is there anything that you wouldn't want a judge or adjudicator to see later on down the line? Perhaps you want to concede on a point to try and do a deal, but you don't want to lose the right to argue it later. Now, if this is the case, any such communications need to clearly be marked that they're without prejudice. Now, the purpose of without prejudice communications is to encourage parties to resolve their disputes by allowing them to speak freely and make concessions without the fear their statements will be used against them in court or adjudication later. So this protection is rooted in public policy and ensures that settlement discussions remain confidential and inadmissible in evidence during litigation or adjudication process. So just put some text on the slide taken from Lord Hoffman, which sets out exactly what the without prejudice rule is. The wording from Lord Bridge on this slide is also helpful. And there's reference here to protection for genuine negotiations. So the privilege does not extend to communications that are not aimed at settlement or where there is no existing dispute at the time of the communication. So the courts apply quite an objective test to determine whether a communication does actually qualify as without prejudice, and they will focus on the intention behind the communication and its context, rather than just on the use of the label without prejudice. So don't try and badge up an email as without prejudice just because you don't want an adjudicator to see it. Perhaps if you want to say something unsavoury, not that any of you would do such a thing, I'm sure, be careful, because unless it has a genuine offer of settlement in that email, arguably the email still can be treated as open despite the fact that you've marked it without prejudice. Now, if you do wish to make an offer of settlement, which you don't want a judge or adjudicator to see at a later date, you must clearly mark any correspondence without prejudice. So don't rely on this at being the start of an email chain. Mark every email in that chain as without prejudice. On a call or in a meeting, make it clear that this is being held on a without prejudice basis, and ensure that the other party or parties agree to this before proceeding. Now, final point to note on without prejudice is that there can only be waiver of without prejudice privilege if there is the consent of both parties. So one party cannot by itself waive privilege to without prejudice communications. Another type of protection afforded to communications is where correspondence is marked without prejudice save as to costs. Now, the impact of this is slightly different to without prejudice communications. So the existence and content of the without prejudice material remains confidential, and the judge and the arbitrator has no knowledge of those communications when reaching the judgment. However, post-judgment, the judge or arbitrator can consider any correspondence that's been marked without prejudice save as to costs when deciding which party should pay the costs of the dispute. A Part 36 offer is a different type of without prejudice save as to costs offer, and it's just a formal offer that's issued in accordance with the civil procedure rules, so it's applicable to court proceedings. Now, it's designed to encourage parties to resolve their disputes without proceeding to trial, and it provides financial incentives and cost consequences for both the party making the offer and also the party receiving the offer. So a Part 36 offer can be made in relation to monetary claims, it can be made in relation to declarations, to counterclaims, to appeals, cross appeals, and it can be served at any time, including before proceedings are actually commenced. Now, the offer must comply with the strict requirements of CPR Part 36 to be valid and to attract the specific cost consequences provided under these rules. So, for example, a Part 36 offer must be made in writing and served on the other party or their legal representative. It can also contain a term specifying that the offer will be automatically withdrawn if it's not accepted, but you've got a minimum period for that, and that's 21 days. So there are cost consequences if a party doesn't accept a Part 36 offer and then is awarded less than the offer at trial. I'm not going to go into the ins and outs of the cost consequences now, but it's a really useful tool for your negotiation if you're in court proceedings or you expect there to be court proceedings in the future, is to think about levels of Part 36 offers. Now, if a party does accept a Part 36 offer, the legal costs incurred up to that date need to be agreed separately. So if the costs can't be agreed, there's a separate court process to deal with the legal costs and how much must be paid by the offering party. So that's the other forms of dispute resolution out of the way. So we're now going to get on to adjudication. I'm just going to start this section by making it clear that I love adjudication. I know that makes me sound perhaps slightly weird, but it's a topic that I'm really passionate about, as well as designer handbags and a decent Sauvignon Blanc. I could talk all day about adjudication, but you'll be pleased to hear that we're going to limit this to finish at 9:30. So for this session, we're going to talk about adjudication and what it actually is, why it is required, what happens during an adjudication, and then quickly, if we have time, we're going to cover the events post-adjudicator's decision. I feel like I did a lot of talking in those slides.
Okay, so a high-level overview of adjudication. It's a 28-day process under the Construction Act. It can be extended to 42 days unilaterally by the referring party, or longer by agreement between both parties. Anecdotally, I think it's quite rare to have a 28-day adjudication.
I don't think I've ever had one.
Oh, okay.
I can't think of when I've ever had a 28-day one.
They're often, the extensions are often driven by the amount of time that the adjudicator needs and the sort of implicit threat that they might not continue if the parties don't agree to an extension. So that tends to be one of the main drivers for timetable. Adjudication is sort of driven by the policy underlying the Construction Act, which is pay now and argue later. And I think that's been brought out in a lot of the recent case law about sort of notified sums or smash and grab adjudications, where you effectively pay the notified sum and adjudicate on the true value afterwards. That's really the whole ethos behind the Construction Act. Adjudication, or statutory adjudication, only applies to construction contracts, which are contracts for construction operations, and we'll come on to that shortly.
So that's what adjudication is, but why does it exist? Well, if you were with us for session 2, you'll know that Sir Michael Latham was asked to look at the construction industry because it was seen as a basket case, and he's worked wonders, and it's no longer a basket case. Anyway, Sir Latham produced a report called Constructing the Team, and the basis of that report was how the construction industry could become less adversarial. So he came up with the idea that there should be more partnering, there should be a new form of dispute resolution, and the supply chain needed certainty of payment. As you know, it was from the Constructing the Team report that the Construction Act was born, which introduced the new form of dispute resolution, which is adjudication. We've put a picture on the slide. Now, this is taken from an article in the East Anglian Daily Times that featured our rather legendary consultant, Dan Leno. And this was just after the Latham report was published in 1994. This article has been doing the rounds in the office recently, just to laugh at how young Leno looks. But it's really interesting to read the thoughts of those in the industry before the Construction Act came into force, which was 30 years ago this year. I'm not sure I completely agree with Leno's closing remark that if the Latham report recommendations eventually become effective law, the real losers could be the lawyers. I'll let you make your own mind up about that statement. So we touched again on this on session 2, but as part of the Construction Act coming into force, it also had the add-on of the scheme for construction contracts. So if your construction contract doesn't have the right provisions in it, the scheme will set out what the adjudication procedure is. So JCT, for example, says that the process for adjudication is the scheme. There are other procedures that can be used, such as the TEXA rules or the CIC rules, but in our experience, the scheme remains the most popular. I should just say on that slide, on that image, I don't know why there are handcuffs on there. They're not relevant to the Construction Act. So what does the Construction Act actually provide for? Well, it gives a statutory right to any party to a construction contract to refer a dispute to adjudication at any time. So as I said on the slide, this covers all construction contracts. So if you've got a dispute, and provided you have a construction contract, you can adjudicate. Hooray. So just to briefly recap from what we said in session 2, a construction contract is any agreement for the carrying out of construction operations. It's any agreement for the arranging of the carrying out of construction operations. So what this is basically saying is even if you subcontract it, you're still caught by it, and any labour contracts. And in addition, and sometimes there's a bit of confusion still in the market about this, all professional appointments are covered by the Construction Act. So architects, surveyors, ground investigators, they're all linked to construction work. So they're all covered. And the number of times that we talk to these professionals, they don't realise that they can adjudicate. So if you're not being paid by a client, you can use adjudication to your benefit. So the wording on the slide is what is a construction contract. This is taken from section 104 of the Construction Act. Also just important to note that a construction contract doesn't need to be in writing. It can be a verbal agreement, and that gives the party the right to adjudicate. Missed a slide there. Section 105 of the Construction Act then sets out the meaning of construction operations. So as we said back in session 2, if you take the time to read this slide, it's actually quite interesting what is covered. Repair and maintenance contracts are covered, site clearance is covered, scaffolding is covered. Sometimes not even a building, but something that amounts to a structure is covered. Painting and decorating is covered. So these are all construction operations, which means they're construction contracts. So just to recap, construction contracts can be oral as well as written. Professional services contracts are included in the definition. Now, whilst it doesn't extend to domestic works, if the parties have entered into a contract that includes adjudication, the parties can adjudicate. So, for example, a homeowner might enter into a JCT minor works with a contractor. If a dispute arises, either party can refer that to adjudication because the contract permits it. Just on the side as well, there's limited oil and gas exceptions, so check section 105 first if you're unsure.
Just to pause there on the homeowner point, there is a case going to the Court of Appeal in a few weeks, I think, RBH and James, isn't it? Which is one of ours, and one of the issues to be decided in that case is whether or not the Mr. and Mrs. James were homeowners as defined by the Act. They say they weren't. We'll see what the court says. So as Hannah mentioned, the Construction Act says that either party can refer a dispute, singular, to adjudication at any time. So that means you can only refer one dispute, and we'll come on to the difference between one or more disputes in a few slides' time. The key point for now is that the dispute must have crystallised by the time that you serve the notice. It can't be afterwards. You can't use the notice to crystallise the dispute. It has to be before. How you define a dispute sounds obvious, really, but there's a lot of case law on it, and even now, in the context of live adjudications, a lot of time is spent arguing whether or not there is a crystallised dispute. Okay, so on the screen and on the next slide is a case called AMEC and the Secretary of State for Transport. And there are some principles in there around when a dispute crystallises. I think the main points for me are points 3 and 4 on this slide and the next, which is that for a dispute to arise, there needs to be a claim by one party which isn't admitted by the other party. And that can be either expressly, as in the other party writes back and says, I don't agree, reject your claim. It could be by implication, so by an exchange of correspondence after the claim, it could be clear that the other party doesn't accept it. They might sort of dance around it and not use the word reject, but ultimately you can tell by correspondence it's not accepted, or they might just be silent. So you might make a claim for loss and expense, say, you don't hear anything but for 3 months, so you can infer that there's a dispute. It's slightly different in the notified sum or smash and grab context, in that if you're the payee, once you make an application, if there are no notices in response, once the final date for payment has passed, a dispute's crystallised. You don't, as the payee or the referring party there, you don't need to do anything extra, i.e. write to the other side and say, final date for payment's passed, pay up in 7 days, or I'm referring a dispute to adjudication. The very fact that the final date for payment has passed and nothing has happened, you've not been paid, no notices, you've got a crystallised dispute. And that's the second lot of principles from AMEC. Okay, case on the screen is one called MW High Tech Projects and BBK, and in that the crystallization of a dispute in the context of a JCT contract, where you've got in the 16 suite, it was a 12-week period for the employer to assess an extension of time. I think the 24 suite unamended reduces that to 8, but in this context it was 12. Halfway through that period, the contractor served a new delay report, and the court ended up saying that didn't necessarily reset the 12 weeks. The 12 weeks carried on running. And I think an important point in that case as well is that the court decided that a dispute couldn't have crystallised until that 12-week period had elapsed. So if you've got a tricky employer who wants to sort of drag things out as long as possible, the thing to do would be to keep hold of any EOT notices for the maximum period, to fend off any dispute. And I think that's a point that a lot of contractor and subcontractor clients struggle with, is that you might make an EOT claim and you've effectively got to sit there and wait it out for 8 to 12 weeks before you can do anything about it.
So you've got a construction contract and you have a dispute. You have a right to refer that dispute to adjudication at any time, but what is the procedure? Well, I've put up on the slide the core requirements of adjudication procedure. So I'm just going to take each one in turn. So firstly, you issue your notice of adjudication. The adjudicator needs to be appointed within 7 days of the notice of adjudication being served. This is because, as I've said at step 2, the referral notice needs to be served within 7 days of the notice of adjudication. Now, this 7-day period can't be extended even if both parties consent to it. The adjudicator's decision needs to be delivered within 28 days of the referral. And as Liam's already said, this period can be extended and commonly is. So for an extension of up to 14 days, the referring party's consent alone is required. For anything longer than this, the consent of both parties is needed. The adjudicator must act impartially, but she or he can take their own initiative in asking questions of the parties, for example. There must also be a period for dealing with slips. Liam's going to talk about this a bit later, but the slip rule basically allows an adjudicator to correct any clerical or typographical error. And this period is 5 days from the date of the decision. So the standard forms have adjudication procedures that are compliant with the Construction Act. As I've already mentioned, JCT forms of contract rely on the scheme for construction contracts to set out the adjudication procedure. If, however, you have a construction contract whereby the adjudication provisions are defective, then Part 1 of the scheme will apply wholesale. Now, what I mean by this is that the scheme won't fill in the parts that are non-compliant. The whole of Part 1 of the scheme will apply and replace whatever process is in the contract for adjudication, whether part of this are compliant or not. Just going off piece slightly, it's really important to distinguish this against Part 2 of the scheme, which relates to payment. So we covered this in session 2. Part 2 of the scheme can be applied piecemeal to replace or supplement non-compliant payment provisions. Part 1, on the other hand, which deals with the adjudication process, is applied in its entirety to ensure that each construction contract has a compliant adjudication mechanism. Now, this isn't a problem when you're using the standard forms, but if you're looking to amend the adjudication provisions in a standard form or include adjudication provisions in a bespoke form, you really need to make sure they comply with the Construction Act. Otherwise, they'll be removed entirely and replaced with Part 2 of the scheme. This slide just shows the standard timetable for adjudication. So an application we made to the nominating body for the nomination of an adjudicator once the notice has been served. The referral needs to be issued no later than 7 days after the notice. Whilst it does vary, generally speaking, the responding party will have 7 days to provide a response, with a further 7 days for the referring party to provide its reply. If further submissions are permitted, the parties normally only have a handful of days to issue these before the decision is then due. Decision is 28 days after the referral, so 35 days from the notice of adjudication from the start of it. But as we've said, this 28-day period always gets extended, usually to around 50 days, I would say, after the notice of adjudication.
So the notice of adjudication is the first document that would be exchanged in adjudication. It's something that the referring party serves on the responding party, and arguably it's probably the most important document in the whole adjudication because it effectively frames the dispute and is the document that gives the adjudicator their jurisdiction. You can't widen the dispute in the referral if you've, for example, missed something off in the notice. So if you want to refer a dispute that's, say, 30 different variations and you only put 25 in in the notice, you can't then rescue that in the referral by adding the 5 that you missed off. If that's really what you want to do at that point, the best thing might be to do to let the notice lapse or pull it and start again. The scheme sets out the minimum requirements for a notice of adjudication, and probably the most important ones are the party details, the details of the dispute, and the redress sort, and we'll come on to the redress sort in a moment. So we're going to look at some case law about the interaction between the timing of the notice of adjudication and the request to a nominating body to nominate an adjudicator. Generally, well, not generally speaking, strictly speaking, it should happen in that order. You serve your notice, you make sure the notice is served, and then you apply to the nominating body, for example, the RICS or TEXA, for an adjudicator to act. The issue with getting it the wrong way around is that that adjudicator won't have jurisdiction because there's no document in play, i.e. the notice, that would have given them that. Still quite surprising how many, sort of on the face of it, experienced people get this wrong. It still comes up quite often that referring parties will effectively ask for a nomination before they've served the notice, and that might be because they've just cocked it up from the start, or it might be that they've not quite understood the service provisions in the contract. But it's always worth looking at those and just ensuring that whatever the method is, that you ensure the notice has landed before you make the request to the nominating body. And if I can, I try and do one late in the afternoon and then the second early the next day, just to ensure that it's clear there one day after the other. Okay, so I think, as I mentioned, if you are a referring party and you realise that you've potentially asked for an adjudicator nomination before you serve the notice, I think the best thing to do at that point is to either let your notice lapse or expressly withdraw it and start again. If you're the responding party, you need to challenge jurisdiction as soon as possible and ask the adjudicator to resign. And this is probably one of the clearest jurisdictional challenges. Often they can go either way, but I think most adjudicators faced with a clear situation where the nomination request has been made before the notice will resign. It's not really something that's arguable. This is a quote from Coulson's book on the screen, just stressing the importance of the notice, but it's really restating what we've already said, which is that it's a really important document, sets the scope of the dispute, and you won't necessarily have the chance to correct it if it's wrong later on. Okay, so there are different types of redress that you can ask for in an adjudication, and there are some that you can't. Generally speaking, you can ask for a declaration, i.e. on the length of an extension of time, whether or not something is in principle a variation, whether a party properly terminated a contract. You can also ask for an order for payment. So in a sort of notified sum or smash and grab context or a valuation dispute, there are certain things that adjudicators can't order. So for example, specific performance, an adjudicator can't order a party to, say for example, correct defects. What they can do is give a declaration regarding the existence of those defects, or order one party to pay another as a result of them, or deductions to a contract sum, for example. Adjudicators can't grant injunctions. That's something that only a court can do. And it's probably worth thinking about whether you're asking for declarations or orders for payment, and how that frames and sort of sets the agenda for the adjudication going forward. If a referring party only asks for a declaration, the responding party is effectively limited to the issues in dispute. If the referring party is asking for a decision, an order for payment effectively, that really opens up the scope of what the responding party can bring in. You can start to bring in cross claims that are outside the issues in dispute. So a classic example is if it's a final account dispute and the referring party is looking for a decision on the value of variations, the responding party can then bring in, for example, valuation of defects, LDs if you want to. So it really does, if you're a referring party, you really need to be mindful that the scope can be opened up. And I think that's particularly applicable at final account stage. On the screen, there are a few examples of what I would call the catch-all wording. So if you are, the classic example is if you have a true value adjudication, you want to say to the adjudicator, we want a declaration that the valuation of these works is X or other such sum that you might decide. The issue is with not including the catch-all wording, as I would call it, that you're only giving the adjudicator two choices, and that's nothing or the sum that you're asking for. And ideally you want to give him or her some scope to go outside that, because I can't really think of a situation in a valuation dispute where you don't necessarily want to give the adjudicator some latitude. Where you might not include that wording is if you've got a smash and grab type dispute and you either get the sum that you applied for or that was in a certificate or nothing. Second point on the screen is that under the scheme, you can't have the same adjudicator decide two separate disputes at the same time under the same contract unless it's agreed. I think if you're referring, you need to be alive to this and potentially let the nominating body know when you seek the second nomination. And similarly, if you're the responding party and the same person has been nominated in sort of two concurrent disputes, if you want to put it that way, that needs to be flagged either to the nominating body or the adjudicator quite early on and make an objection to jurisdiction. There's some commentary on the screen about multiple disputes. This is something that there's been a recent trend by the court, or probably best to start where we were a few slides ago, in that you can only refer one dispute to an adjudication at one time. And generally speaking, a final account dispute with, say, multiple variations and loss and expense, that's one dispute with multiple sub-issues. There has been a recent trend by the courts, and the case that springs to mind is Bellway and Sergo, where the court has taken quite a liberal approach to whether or not things are necessarily one dispute or separate disputes. And in Bellway and Sergo, the referring party referred a notified sum and true value dispute for the same payment cycle to adjudication. The court ended up saying that was okay. I had reservations about that at the time. I think really I'm sort of fighting against the tide, and generally speaking, courts are quite liberal on that, supportive of adjudication. I think as long as it's not completely clear that you've got two separate and unconnected disputes, generally speaking these days, I think it's one dispute.
So once the notice of adjudication has been validly served, the referring party will need to ensure an adjudicator is appointed to act as adjudicator and have the dispute referred to him or her. So the referring party needs to check what the contract says in relation to the nomination of an adjudicator. And this is really, really important, because if this process is carried out incorrectly, it will render the ultimate decision unenforceable. So check what your contract says. Is there an adjudicator named in the contract, which happens? Or if not, is there a nominating body? Who is that nominating body? So more commonly, the adjudicator nominating body, or ANB, is the RICS, but it can be other entities as well. A point to note, you're not allowed to shop around for your adjudicator. So if you've got an adjudicator you don't particularly like because you had a bad decision in the past, you're not allowed to say that you've got some sort of conflict to try and avoid getting that adjudicator in the future. And there's been a couple of cases on this. The big one is Eurocom and Siemens. So This involves significant issues regarding the appointment of an adjudicator and the implications of fraudulent misrepresentation in the adjudication process. So the court held that there's actually an implied term that parties must not act dishonestly when applying for the nomination of an adjudicator. So in this case, Eurocom made a fraudulent misrepresentation by listing individuals in the RICS application form as having conflicts of interest, when in fact they were just individuals that Eurocom didn't want to be appointed. This false representation was deemed to be fraudulent or reckless, and the court ruled that such conduct amounted to a breach of the implied term, which invalidated the adjudicator's appointment, meaning there was no enforceable decision. So you've just got to apply to a nominating body and get on with it. This slide just states the part of the judgment makes this point. Don't try and put names in the form to the nominating body of adjudicator you don't like and dress it up as a conflict, because it just won't work. So you've now got your adjudicator appointed. The next step is for the referring party to serve the referral notice. So I've already said this must be served no later than 7 days after the notice of adjudication. And as we've said, this period can't be extended. As I've said on the slide, the referral needs to set out the referring party's case with all documents in support. It needs to be comprehensive, and they aren't always comprehensive, but it needs to have evidence, which includes witness evidence where you need it, and sometimes expert evidence too, if this is appropriate to the dispute that's been referred. Now, the burden of proof is on the claiming party. So you may have heard of the phrase, "he who asserts must prove." It is for the referring party as the claiming party to evidence its claim. Now, in practical terms, we like to have the referral drafted before we even issue our notice of adjudication, so we're not panicking to get this drafted in that 7-day period. However, this isn't always possible, but you've always got to be mindful that you've only got 7 days, so make sure you've got your referral notice, if you can, ready. So this extract from the Hart Investments case on the slide just reinforces the point that the referral needs to be served not later than 7 days after the notice of adjudication. If you do issue it later, this is a reason for the court to resist enforcement of the decision, which you don't want.
So the next submission is the response, and as the slide says, you often get, say, between 7 to 14 days, depending on the type of dispute. If it's a relatively self-contained smash and grab, you might get 7 days. If it's something more complex, extension of time, loss and expense, something like that, you might get towards the end. Even with 14 days, you tend to be up against it for time, because the referring party might have had months and months to put together submissions and expert reports, and depending on how well prepared you are, you might have 14 days from a sort of cold start, or you might have had a bit of a warm up. Generally speaking, in that period, you're clearing the decks at work and home, and everything goes towards that response. It's probably important to double check the referral. I think focus on the key issues. Depending on who the referring party is, sometimes submissions can be quite sort of meandering, to put it nicely, and it's important to sort of take a cold look at it and work out what's really key in there and focus on those issues, and also gather relevant evidence. So, as Hannah mentioned earlier, similar to a referral, you might need witness evidence on certain points, you might need quantum delay evidence. So gather all of that, get that ball rolling, and then start work on the submission. There are a few dark arts that you can deploy if you're a responding party. You might be able to lean on jurisdictional issues to sort of get your own way with the timetable, but ultimately you're looking to do the most you can in the time available, which often isn't a lot. The next submission is the reply, and in most straightforward disputes, that's often the last submission, although sometimes you can get sort of in an inception style 5 or 6 submission type situation in a more complex dispute. Often this will give the referring party the chance to address new allegations in the response. So there might be things that weren't part of the scope of the dispute originally. We mentioned earlier LDs or defects. They might not have been dealt with in the referral, so the referring party will get a chance to address those in the reply. And often it's a chance to potentially cover off gaps or things that you didn't quite major on in the referral. One strategy which I think should be deployed fairly rarely, but it is an option, is to potentially, for the referring party, to save up evidence for the reply. It might be that you've got a report that you don't want to give initially. You want to sort of almost tease the responding party out before you serve it. Although I think that's quite risky, one, because the adjudicator might restrict the scope of the reply. And I think generally speaking, this is sort of anecdotal really, but I think adjudicators tend to give more weight to the early submissions, i.e. the referral and the response. And I think as things go on, less weight and attention potentially is given to the later submissions.
So after the reply, you'll nearly always see another submission from the responding party, and then perhaps a final submission from the referring party, and sometimes more if it's a complex dispute. However, all of these submissions are at the adjudicator's discretion. There is no actual right to issue further submissions, and the quote from the Barry M case on the slide is just a reminder of that. So just taking a step back, adjudication is a 28-day process. There just isn't the time for countless rounds of submissions. And in reality, by rejoinder stage, the parties are just repeating themselves anyway, which is not of any use to the adjudicator when deciding the dispute. Occasionally, you might have a meeting in adjudication, but this is rare. It tends to happen if there are defects that can be inspected by the adjudicator, or perhaps where there is conflicting witness evidence and the adjudicator wants to see the whites of the eyes of the witnesses, so to speak. More often than not, though, adjudicators reach their decisions on paper submissions alone.
Right, okay, so we're at the end of the 28, 42 day or longer period, and the adjudicator issues their decision. I can't think of an example where I've seen a decision without reasons. They usually include reasons. As the slide said, some are better and more detailed than others. And I think a well-reasoned decision, whether you agree with it or not, is really helpful, because I think you can at least take clients through the adjudicator's thought process. What's more tricky, I think, is where a decision isn't necessarily reasoned out, or there's gaps in it, and you're trying to second guess what the adjudicator's thinking, because once they've given their decision, they've no longer got jurisdiction. There's no obligation on them to sort of explain bits to you afterwards. Hannah mentioned the slip rule earlier. There is a rule under the Act where within 5 days after the issue of the decision, the adjudicator can correct slips. And often that leads to a sort of almost satellite dispute about potentially whether something is a slip or not. It's confined to clerical or typographical errors. So we are talking about potentially misnaming one party in an order for payment where it clearly should have been the other, potentially a misplaced decimal point, a list of figures that doesn't quite add up. So it's quite important, I think, particularly if you've got a big valuation decision, to double check the maths within the first couple of days. And if there's an issue, you can let the adjudicator know. I think a lot of adjudicators are really alive to this, and I get the impression that the figures are checked and checked again. So it's very rare to find a sort of error with figures, but it does happen.
Adjudication costs is something I want to cover next. So here I'm talking about the costs of the adjudicator and not each party's legal costs of representation in the adjudication. So the parties to an adjudication do not have a right to claim their legal costs of bringing or defending an adjudication unless the parties have expressly agreed this prior to starting the adjudication, which is really rare. So generally, unless it says so otherwise, each party bears its own costs in adjudication. Now, the adjudicator has discretion to apportion his or her fees as he sees fit. So normally adjudicators' fees follow the event. So if a party is successful, the losing party has to pay the adjudicator's costs. But quite often there's rough and ready apportionment of this. So adjudicators might look at, have any unrealistic claims been made that haven't been successful? Have submissions been unnecessarily long with case law that's not relevant? Adjudicators can consider all of those things. One point that's really important to remember with adjudicators' costs is that the parties are jointly and severally liable for these fees. So even if the adjudicator decides that the responding party must pay 100%, ultimately, if the responding party doesn't pay that, the adjudicator can go after or sue, bring a claim against the referring party or the responding party or both to recover those fees. Quite often you will see an order on costs that says the referring party has to pay all the adjudicator's fees in the first instance and then claim any payment from the responding party back either in full because the referring party's won everything or in part, or even if the referring party has lost, sometimes you have it vice versa. But just to be mindful, the adjudicator basically can do what they want on costs. This is just a quick slide on the pros and cons of adjudication. Pro is that there's no limit to the value of dispute. This is also a con as well. Pro is an adjudicator. It will be a construction specialist. Con is the adjudicator. We get such a wide variety of decisions from adjudicators that when a client says to us, are we going to win this adjudication? We can never tell you because we have seen some bonkers decisions. Pro is the time limit. You get a decision in a really short period of time where you'd never get that in court proceedings. Con is a time limit. You basically are working on a submission and doing nothing else for 7 days if it's a massive dispute, and that can be really hard work. Pro is there's no limit on paperwork. That's also a con as well. You can be absolutely bombarded with stuff relevant or not to a dispute. Pros with adjudication, straightforward enforcement, and this dispute resolution mechanism is fully adopted by the industry. Everyone seems to know what construction is, and most people, they get an adjudicated decision. Even if they don't like it, they don't tend to have that dispute decided by the courts or arbitration. People just draw a line under it and get on with it. I'm just going to really quickly run through this in the last 2 minutes that we've got. Enforcement of decision. So if you get a decision, perhaps referring party has succeeded, responding party has to pay referring party some money. If the responding party doesn't do that, there's a quick fire claims procedure in the Technology and Construction Court where the court will enforce that decision. So it's a very standard procedure. You issue a claim form with a witness statement and a couple of applications. You'll get a hearing probably about 6 to 8 weeks after you issue that claim form. It's all in the Technology and Construction Court. And then assuming that the court does enforce the decision, which Liam will quickly come on to, there's very few reasons why they won't. You've then got a court judgment to enforce in the usual way against the party that lost the adjudication. So you can put a charging order on property, you can issue a winding up petition, you can send the bailiffs round, you can get a third party debt order to freeze any money in account. So it is really important that adjudication decisions are adhered to, because if not, the winning party can go to court and get a court judgment off the back of it.
Okay, so very quickly, grounds to resist enforcement. As we mentioned earlier, the TCC is very supportive of adjudication, and the grounds for resisting enforcement and the likelihood of the court allowing it seems to be getting more narrower each year. Probably the key grounds to resist enforcement are a lack of jurisdiction, or a breach of the rules of natural justice. Something that isn't necessarily mentioned on the slide is there's been a string of cases over the last few years about insolvent companies looking to enforce adjudication decisions. It's acceptable in principle, but there are fairly tight restrictions on it, i.e. one, the decision needs to deal with the overall net position between the parties, so effectively a final account decision, assuming that there's only one contract between them at the time, and the claimant, which will be the insolvent company, needs to give security, one, for the adjudication sum, 2 for the costs of enforcement, and 3 for the costs of the proceedings to decide the dispute later on. And that is often hundreds of thousands of pounds, and for the most part is a bar to those companies enforcing. So again, be alive to any claimant in enforcement proceedings being insolvent and what you can do about it.
And that's us done, just 1 minute over time. We did have some questions come through throughout the session, and we had some questions in advance. So I'm not going to answer them now, but what we'll do is what we usually do, just put them in a document and circulate that to everyone. If you've got any other questions following this, please, of course, let us know. Otherwise, have a great day, and we look forward to seeing you for session 6. Thanks very much.
Thank you.